Good morning, everybody. I want to introduce myself that I'm Dr. Tina Melia from University of Borobudur and my friend for exactly Dr. Halilur Rahman from Jayabaya University. Today is really special day because I want to present my article about the formulation of specific personal data protection in relation to court decision. And from the introduction, exactly, I want to tell about the protection of personal right in Article 28G, Paragraph 1 of the Constitution of Republic Indonesia. It's talking about the basic for implementing the constitutional right to personal protection. And then the right to privacy as an object of personal protection. And then the technological development, the government implement e-government by utilizing a big data, Internet of Things, and artificial intelligence, and etc. And for protection of personal data on crime records. The criminal records, including court judgment, are protected by Law Number 27 of 2022 concerning personal data protection. And 5 about the publication of court decision. The court judgment law from the disclosure of criminal record. So what is the position of court judgment in the concept of personal data protection in Indonesia? Yeah, we have to discussion about the utilization of information technology result in the eases the collection and transferring of individual personal data from the party to another without the knowledge of the data subject, thereby positioning a treatment to the constitutional right of the data subject. And then the protection of personal data falls within the realm of human right protection. And then the personal data protection law is mandated by Article 28G paragraph 1 on the Constitution of Republic Indonesia, with statement that every person has the right to the protection of their personal self, family, honor, dignity, and asset under their control. About the issue of the personal data protection raised due the concern about violence against personal data that individual and or legal entity might experience. Such violation can result in material and non-material loss. Adequate protection of the personal data will be able to instill public trust in providing personal data for various broader society purpose without it being misused and violating their privacy like. So from that explanation, the object of the personal data protection according to the personal data protection law is about the specific personal data and the general personal data. About the specific personal data, we can talking about the health data and information, biometric data, generic data, crime record, child data, personal spatial data, and or others data in accordance with the provision and legislation. Now, about the general personal data, we can talking about the full name, gender, citizenship, religion, material status, and or the combined personal data identify an individual. So we know about the differences about the specific personal data and the general personal data. Next, and we can talking about the correlation between the personal data and the protection and court judgment concerning criminal records are stated in Article 4, Paragraph 2, letter of the personal data. The protection law relates to the principle of the open court proceedings and the publication or the legal binding court decision to the public, and the court judgment are also part in criminal records as the reflected person legal status regarding the action. That is very important to ensure that the criminal records and court judgment are created and access while upholding and the principle of the fairness, privacy, and the protection of individual rights. The principle of the presumption of innocence must be upheld, and only relevant and necessary information might be used in decision making based on the criminal records. So next we will talking about for exactly next to the result of the court judgment are typically read openly and published to the public. This is done to provide legal clarity, deterrence against the lawbreaker, and dissemination information about the legal decision on the public. Okay, however, when reviewing the personal data protection law, there's the conflict between the principle of open court proceedings and the protection of the personal data. Therefore, a judgment to the personal data protection can be a solution to balance the principle of the open court proceedings with the protection of the personal data. In this context, criminal records originating from the court judgment can be exempted from the privacy protection governed by the personal data protection law. This law court judgment and very relevant criminal records to remind public information and accessibility to the public. So the court judgment are expected to be included from criminal records and instead by the personal data protection law from the parse criminal record, and then therefore is a need to formulation regarding to conception of the regulating criminal record that do not include court judgment in the concept of the personal data protection. And then from the Article 4, Paragraph 2 of the PDP law that talking about the existing regulation, personal data protection law, and the specific personal data is reversed in Paragraph 1, letter E include health data and information, biometric data, generic data, crime record, child data, personal financial and data others data accordance with the provision of the legislation, and the concept very different with the concept of the specific personal data referred to in paragraph 1 letter includes the biometric data, generic crime record, but the crime records refer to written records about the individual who has engaged in unlawful act, the violence, the law is undergoing a legal process for their action. And next, about the conclusion, something that really important, that the court judgment should be excluded from the concept of criminal record in personal data of law, and then in the context personal data protection, it is important to consider court judgment. They are free, open to the public. The Article 4, Paragraph 2, it's making it close and giving the impression of hiding and covering of the information. In this regard, there is a need to formulate it of adjust to personal data protection law to exclude court judgment from the concept of the criminal records. This exemption will ensure fairness and legal certainty regarding the disclosure of the information that should be known the general public. Okay, thank you for the attention. I'm Dr. Tina and Dr. Halilur Rahman. Say thank you so much from this international conference on law the reform, and see you in next moment.